Recently, we observed that the Chamber of the Turkish Court of Cassation in charge of IP matters dismissed many more decisions in comparison to previous years, interfering into inferior courts' areas of discretion. This intrusion has consequences, such as an increase in the number of the files before the courts, as well as the duration of their examination. In this video, we want to draw your attention to this important topic and we'll talk about the supervisory power of the Turkish Court of Cassation with a special focus on IP matters. My name is Güldeniz Doğan Alkan. I'm a litigator specialized in Turkish trademark law for 15 years. Prior to 2016, the year the Regional Courts of Appeal started to operate, a binary judiciary system was enforced in Turkey, in which only first instance courts and the Court of Cassation were operational. Currently, a triple judiciary system is adopted where there is an intermediary step between the first instance courts and the Court of Cassation called Regional Courts of Appeal. Before the inauguration of Regional Courts of Appeal, the Court of Cassation used its judicial power as a review of expediency and carried out an examination as to the merits of the case, whereas its main role is to act as a court of precedence. This main role became clearer after the creation of Regional Courts of Appeal. The transition from a binary to a triple justice system serves the purpose of ensuring that the Court of Cassation acts as a court of precedence and its examination is limited to a legitimacy examination. Recently, particularly in some reversal decisions rendered by the 11th Civil Chamber of the Court of Cassation in disputes related to trademark and design law, we see that it acted much like inferior courts. It reviewed cases and passed judgments in a manner at odds with its position as a Supreme Court or a court of precedence. Within this context, we observed within the last 1 or 2 years that the Chamber carried out its own assessment in numerous cases by ignoring the findings in the expert reports, as well as the initial assessments made by the first instance courts and regional courts of appeal on matters related to the merits of the case, such as similarity of trademarks, similarity of goods, services, relevant consumer group, well-known status of trademarks and damaging conditions thereof, registration in bad faith. However, the appeal examination to be performed by the Court of Cassation shall be limited to a legality examination. In our opinion, technical aspects we just mentioned shall legally fall outside the scope of the Court of Cassation's authority and examination of legality. We consider that performance of such examination by the Court of Cassation would mean annulment or disabling of the power and duty assigned to the regional courts of appeals, which have jurisdiction to review the first instance court's decisions in terms of expediency and legitimacy and to rule again after a trial of material facts and evidence. According to our current system, after a reversing decision, a case is remitted to the inferior court, making a retrial within the framework of the reversing decision if it finds it justified. Taking this into consideration, we are of the opinion that when the Court of Cassation finds the inferior court's decisions unlawful as a result of its legitimacy examination, it should render reversal decisions in a way to not eliminate the discretion of the judge of inferior courts, such as indicating which rule of law is incorrectly applied or, indeed, how they should have applied it. In cases where the Court of Cassation makes an examination with respect to the merits of each case in a manner exceeding the scope of a legitimacy examination, the long years of examination and assessment made by the judges of inferior courts during trials based on their areas of expertise would become vain and without merit. Also, the workload of the Court of Cassation would not be reduced as intended by the transition into the triple justice system, but it would increase to the contrary, and the duties of the Court of Cassation as a court of precedence would be impeded again. As required by the triple judicial system, we expect the Court of Cassation to perform the appeal examination limited to a legitimacy examination without interference with inferior court's discretion. We hope that the Court of Cassation will focus on its role to act as a court of precedence so that the case law of the Turkish courts may develop and flourish. You can find more concrete data on this topic in our thought leadership paper for this year. Thank you for listening to me.